Welcome back to another, I guess, podcast that we are putting on. My name is Jason Wood, and along with Lee Maddox and Michael Maddox, we are partners in a nationwide brokerage company.
Okay, so we've completed the letter of intent. We've gone through due diligence. The buyer has loan approval. Everybody's a go. Now we're waiting for we're waiting for the asset purchase agreement. Who typically prepares the asset purchase agreement? Do you think it should be done by a broker, by a lawyer? Should it be done by the seller's broker, by the buyer's broker? I'm sorry, the seller's lawyer or the buyer's lawyer?
Oh.
Yeah, let's get into that. And are there different? Are they all the same, Jason? Does one crown fit all teeth?
It does.
Asset purchase agreement work for all transactions?
Absolutely, yes. What I have found working on a national basis is it's all over the place. Some geographic areas, the buyer is the assumed person who's drafting the purchase agreement. In other areas, it's the seller. Depending upon where I am in the country, I'm malleable. I'm moving to where the parties are. If a broker drafts, I'm okay with it, depending upon the broker. There are definitely some brokers where I'm like, you are staying as far away from this transaction as possible because I know your documents are extremely one-sided, and the only person that document is protecting is the broker. So it really depends. If I'm representing a buyer and the seller wants to draft, I'm not opposed to it. I do have a follow-up question, and that is the seller's attorney someone who has done this type of transaction in the past or not? If they haven't, then I'm more forceful, saying, let us use our own documents then, and then they can review. But for me, I'm not the type of attorney who's like, it's got to be this way and this is the only way, because dental practices are unique. Every single dental practice that we come across is unique. Location, personalities, procedures, everything is unique. And yet so many people want to just assume that one square box goes into one square box. And that's how it is throughout the entire United States. And it's not. I mean, how I deal with a dental practice in Massachusetts is very different than how I deal with a dental practice in Georgia. If I try to deal with the Georgia dental practice the way I would, a New England practice, they're going to look at me like I'm a crazy person. It's just how things are done, and things are done differently. And it's important to know those differences. But I think the most important thing is you can't assume when you're doing dental practice transitions that your way is right. I think as you know, when I was young and dumb and naive and doing transactions with you, I was very opinionated. I was this is the way it has to go. And when we went national, when we started doing these things, I quickly had to learn that I'm not always right. And when I learned that, I was able to help clients more.
There are people not believing you right now.
Oh, I know. Trust me, I know. They're like, that guy's full of, yeah. But yeah, it's just, there are. Look, I always zealously represent my client. If I'm representing a seller, if I'm representing a buyer, but it doesn't have to be my way. 20 years ago, when I was cocky, not confident, it had to be my way, and I think I was doing a slight disservice to my client, even though I was doing great. But now that I have more knowledge, I've come across hundreds of different people. It's helped me realize that there's, what's the saying? There's plenty of ways of skinning a cat.
I thought you were going to say best ever. I just do the best. I'm the best. I do the best ever. No. Nobody does it better than me.
I'm just a hustler, baby. No. Nope. There are some good attorneys out there. The scary part is there's a lot of bad ones that hold themselves out as dental attorneys, and I'm like, are you?
I agree. I mean, we get the documents from all different places, and they all have some language that seems to have been shared from one biblical source of asset purchase agreements. That language just seemed to be translated in 15 different languages, and we see it in all the documents, and it's like verbatim. You'll see the same stuff. So I think the topics are covered in a lot of them. I think, unfortunately, there's a lot of purchase and sale agreements that are they're not coherent because people don't understand what defined terms are and they don't draft clearly or they're wordy. And my concern is a seller's representative or a buyer's representative, if we're going to litigate that, if I haven't drafted the document, I don't understand. If someone gets me on the stand and says, what does this paragraph mean? Why was the sentence written this way? I'd have a hard time answering that question because I didn't draft it. And if it's less than clear, then, it's subject to many different interpretations. And so in a litigation matter, that could be a problem. But having said that, I don't have that control to demand that every deal gets, prepared by us. If it's my transaction with my seller, I'm generally going to force that I want to draft the document.
When you're the broker or when you're the attorney?
Both.
Both. Okay.
I mean, I don't win all the time, but there are times when I have to work with brokers' documents, but there's more red than black left when I'm finished with it, and that seems to create a lot of anxiety or angst on the other side. First off, I think the brokers are embarrassed when they have to show the document back to the client that they're working with because they represented it. They represented that when they sold the practice, they were going to present a document that's been seen by many attorneys.
Hundreds
And
of
people
attorneys.
love them, and they never have any changes. And the fact of the matter, it's trash, right? It's not a cohesive document at all. And so, yeah, I think on those transactions, I know the players, and I will tell my buyers in advance that, we got this document. The seller hired this broker. The broker represented they were going to do this agreement, so we're stuck with it. But for legal reasons, I need to make this make sense. So, because if we go into court later, I have to be able to stand behind what I'm looking at. And if there's not defined terms, and by the way, most brokers don't even know
what a defined
what
term
it
is.
means, and there's a lack of congruency through the document. So anyways, so that brings us back to why are these agreements so long? I mean, when your dad started doing this back early, probably 80s, they were probably 10 pages, and now the average one is probably 30 to 40 pages long. What's happened? Why do we see the documents getting longer? And what's important in these documents if you're on a seller or buyer side? That's a loaded question. It might take you the rest of the day to answer.
No, it's okay. Well, I mean, law typically is evolving all the time. And the beauty about law is sometimes it's advancing, sometimes it's retreating, based upon how the interpretation is. I think that as this industry has grown, we have learned through successes, we've learned through failures as to what's important, what's needed in documents. One of my favorites is we used to just have a covenant not to compete and maybe a covenant not to solicit. Well, we started to find that some, let's just say, less than stellar sellers who were maybe in their mid-40s or late 40s would sign agreements, and the covenant not to compete would be for 10 miles in 5 years. And they would then go 10.1 miles away and open up a new practice. And they wouldn't be competing and they wouldn't be directly soliciting, but all of a sudden 60% of the patient base just magically started going over to their practice. And so learning from that, there's now a covenant not to treat. And the covenant not to treat says, hey, you can go 10.1 miles away, still can't treat that patient. And some of the things that we put in may or may not be held up by a court, but I'd rather have a giant stick saying, if you do this, we're coming after you. And so, that's how these documents develop. It unfortunately comes through usually heartache from something that happened in the past. And so I think I talked about it on a different podcast that, our reps and warranties, we have 30 to 35 reps and warranties. There's a great story behind every single rep and warranty as to why we put that in the document. And when I'm representing seller, there's not 30 or 35. There's 10, 11, 12, because it's not my job to protect the buyer. And so I think a lot of people need to understand that documents are presented in a way based upon who's the one preparing the document. If the seller's counsel is going to be preparing the document, it's going to be a shorter document. If the buyer is going to be presenting the document, it's going to be a longer document. That's why I struggle with attorneys who have one document and they're representing a buyer and then they're representing a seller. Same document. I think they're doing a disservice to their clients both times. And so for me, the evolution of this industry has led to the evolution of the purchase agreement. And the reason why these purchase agreements are longer, the reason why we have complicated AR language, why we have complicated uncompleted dental language, why we have, retreatment language, why we have, how are we handling patient credits? How are we handling all these things? Because experience has taught us that they're important.
Yeah, I agree with all of that. I think that litigation leads to longer documents,
Yes.
right? And you and I have a ton of experience, but still we're faced with things every day where we don't have the answer, right? And we may have to go to other sources and other colleagues to try to figure out the information. And I think that's important for people to know out there, that everybody in dentistry might think they're the most important person in dentistry and they're giving you advice. And just because somebody did one transaction doesn't mean they have the knowledge that's necessary to help you with your transition. And just because you have a family member who's an attorney doesn't mean they understand anything about the complexity of a dental transaction. And in the dollar amount doesn't determine the complexity of the transaction. So you may have a family member that does $100 million transactions. The legal terms are similar to ours, but it doesn't mean that our transaction is not an important transaction just because it's $1 million transaction, right, or a $500,000 transaction. So I think what happens, and I like to say that in my world, I see a lot of problems, unfortunately. When deals go bad, I get called. When situations aren't going well, I get called. And so when that happens, then we start drafting more language and more language and more language, and the documents get longer. It's interesting, and you see this on the DSO space. We get 10, 12, 15 documents for a transaction that might be $1.5 million transaction. And in our private practice transactions, we have one document,
right,
with several exhibits, maybe a bill of sale, maybe a covenant, but the contrast between what we're getting from the DSOs and what we're getting on private party transactions, it's a huge canyon difference, right? And those DSO transactions, the buyer's preparing the document, and there's a great deal of reluctance to make a lot of changes in their documentation. And so this comes back to a DSO transaction or a private party transaction, people advising our clients that they don't need to have an attorney. There are documents that are used all the time, and we're not going to make any changes.
Right.
And so what I have to say is, to the buyer specifically, part of the process of going through an asset purchase, or part of the process of hiring an attorney, is to review the asset purchase agreement and get an understanding of what that legal document says and how it impacts you, especially in a DSO transaction. And if one side of the party is represented by an attorney and you're not going to choose an attorney, just stamp stupid on your forehead, because you're going to get screwed. I think you said it earlier. If you're drafting for the seller, you're supposed to zealously advocate for your seller. You're going to draft a seller-sided document. If you're drafting for the buyer, you're going to draft a buyer-sided document. And there's no attorney on the other side. You do this, right? I'm going to get everything I want, and in an aggressive way, right? It's not even going to be close. So I think that the in my experience from years and years of doing this, there is a perception out there that attorneys kills deals, attorneys slow down deals, asset purchase agreements are too long, the information is not necessary, and this is being decided by people that used to sell cotton pellets 5 minutes ago and now experts in selling dental practices, right? So there are people that have no business at all interpreting the legal terms of the document, opining on that we don't need them, or they're too long, or you don't need to have an attorney reviewing it. And so I have to say, both buyers and sellers have to be really careful. If there's an attorney on one side, have an attorney on the other side. I think another mistake is to bring family members in that have no knowledge about your business. They want to help. They tend to over-involve themselves, over-engineer the contract, and a lot of those transactions will fail because they'll worry about issues that have no legal significance or no importance in the transaction. They may be important in bankruptcy law. They may be important in estate planning. They may be important in franchise tax law. But for your transaction, there are some core concepts in the documents that we really want to make sure are hammered out. Buyers are buying the practice as is, with all faults, subject to the warranties that are made in the agreement by the sellers, which is why you're putting in a whole bunch of warranties. You're on a fishing expedition. You want the seller to disclose as much as they can, because if we're buying it as is, subject to those warranties, we're only going to get to protect the contract to what those warranties are. And that's why you're taking a document that has 10 warranties and turning it into 30 warranties to make sure that the seller's disclosing has there been litigation? Have they paid their taxes? Is there a tax lien? Are there any judgments? Have they had any dental board complaints? Do they have any ERISA complaints? It can go on and on and on. Right. Are the covenants, representative? These are all things that we need to know about the transaction. And what's interesting, and as I was trying to say earlier, is like some of the larger law firms that are representing the DSOs, when they're drafting documents on the buyer side, there might be 40.
Right.
I mean, there literally might be 7 pages of indemnifications. What's interesting about it is if you happen to go against one of those law firms where they're representing the seller, there's going to be 10, warranties. And when you put in 7 pages of warranties, they're going to scream and yell, "Oh my God, what are you doing? You're killing the document." But that's exactly what they do back on the other side.
I don't want to cut you off, but I literally just had that happen where I had a large law firm who was representing a buyer. I knew exactly what was going to happen. I took their language when they represented the seller and literally flipped it in, knowing exactly what the response was going to be. And I waited, and they said, "This is ridiculous. You can't be asking for all these things." And I said, "I completely agree with you, but it's not my language. It's yours."
Yeah.
Just it was great.
No, and what's frustrating is we don't want to kill the deal for our client.
No.
But we do want a level playing field, right? So what's important in a purchase and sale agreement? What are the main things that you think need to be addressed in a purchase and sale agreement to manage the transaction properly?
Well, it's a great question. I mean, what are we buying? If I'm representing a buyer, what are we buying? We're buying goodwill. That's what I care about protecting. I care about protecting the long-term goodwill. How can that be harmed? And that's how I analyze the document. It can be harmed by bad reviews, bad employees, you, the seller, violating the restrictive covenants, something happening where, you're besmirching me after the fact. So I tend to, even when I'm dealing with a lease, I tend to look at how can the goodwill be negatively impacted? And I go from there. And I think it's interesting that you say a lot of people paint attorneys as deal killers. And I would agree that there are definitely some attorneys out there that are. You should not be hiring a litigator if you are trying to buy or sell a dental practice. The fact that your husband or your wife or your best friend is a litigator is not a positive. It's actually a negative for you. And so, but what I love is I represent people nationally. I am not on a single broker's recommended attorney list. I'm not on a single DSO buyer attorney recommended list.
Do you need some therapy?
I don't.
Don't feel loved?
No. Are you kidding me? I love it because somehow I'm still doing more than anybody else. And yet I have a lot of detractors. But the reality is that it's funny because I still am able to close more than anybody else too, and yet I'm the big bad wolf. So I think that there are core concepts that you need to focus on, and then there's a lot of things that you want to try to get but aren't needed. Like if I can get 9 out of 15 of the second tier issues, wonderful. But do I need all 15? No, I don't. But there are some core concepts that I believe are extremely important.
Jason,
And
some people would ask, why would you ask for the 15 if you don't think you're going to get the 15?
because you never know.
No, but why are they even issues and why are they being put in the document?
Because they're second tier issues. They're issues which can impact in the future.
So there's things you've seen in the past that come up.
Absolutely.
And if you didn't have that drafted in the document, you'd be saying, why? Why didn't I draft
Right.
it in the document?
Right.
But if you put it in the document, you don't get it, then you will say, I've asked for it and they didn't give it to me, but it's not
Here's
a
the
deal, but
risk.
it's not a deal killer
Right.
issue.
Here's the risk to you. You're a big boy. You're a big girl. You can make your own decision. But I want my clients to be fully informed. One example that I love giving, and I probably give it too often, but we insert a provision that says the seller is not waived co-payments. Okay? About 40% of the time, that's objected to. And some people object to it strenuously. Like, I'm not going forward with this deal. Like, it's a deal killer. And people get very emotional about that. But like you said before, it's a fishing expedition. I want to know why. So, okay, why did we object to this? Well, I waive co-payments for my friends and family. Okay, that's not a problem. Like, that's fine. How would you agree that you occasionally waive co-payments, but in no event more than 5% of the patient base? Yeah, I could absolutely do that. Great, wonderful. Let's revise it. Versus, well, I have 3 union contracts. 65% of my of the patients are union, and I waive 65% of my patient base co-payments because if I don't, the unions will leave. Okay. Again, not necessarily a deal killer, but the buyer needs to know. The buyer needs to know this is the type of practice. And I want to be clear, I'm not wearing the white wig on this. Like, if that's the type of practice and my client is okay with it and they understand the risks, they understand the benefits, and they still want to move forward, great, wonderful. But it is the discovery that's important. And then determining whether or not this is something that we can live with or not. And so that's why the 9 out of the 15 or the 7 out of the 15 or whatever, it's important, but maybe it doesn't rise for this particular transaction. It doesn't rise to the level of importance to back off of the deal.
Right.
It could, but it might not. So,
okay, so the major parts of an asset purchase agreement, we're having the seller make representations that the buyer can rely on. We have the buyer making representations that the seller can rely on, that they understand the risk, they've done their due diligence, they don't have dental board control, these types of things. Then we have issues that relate to pre-closing operations, like the seller maintaining the operation of the business pre-closing. And we have a lot of post-closing issues that we deal with, which we've mentioned a few times: accounts receivable, retreatment, uncompleted dentistry, and covenants not to compete.
mm-hmm.
And so, do you see that treated equally in all the documents? Or, like I said, you think the seller's documents are thin, the buyer's documents are too thick? On the post-closing issue, don't you think everybody should agree on uncompleted dentistry and retreatment on how it should be handled, since it's a patient management thing? Shouldn't there be kind of a consensus that we're trying to put something together that will benefit the patient the best and maintain the goodwill the best? Why is that? Why are those contentious issues and uncompleted dentistry and retreatment? Why would people fight those issues?
Well, I don't. So again, going back to every region is different. There are certain regions that spell out, okay, you're going to get, this is how we're going to deal with uncompleted dental. The weird thing for me is certain regions, their de facto provision is the buyer assumes the uncompleted dental. The buyer, it's an asset of the practice. And so now all of a sudden, and this is where I do have an issue. Now all of a sudden we're commingling malpractice because we've started a procedure, okay? And now all of a sudden the buyer is going to pick it up here and complete it. And for me, that is the one time where I'm like, I don't know who's the big honcho, the big bad wolf in this region of the country, but you guys all got it wrong because you have drastically increased the liability to all parties.
Yeah,
because
it's a seller problem as well.
Absolutely. That's the point, right? It's going to be a pointing of fingers. It increases the likelihood of litigation, increases the likelihood of dental board issues.
Yeah, and it requires a financial understanding of where the transaction's at as well.
Right.
Prepaid, not prepaid, partially prepaid, lab expense paid, lab expense not paid. So many factors that make it confusing.
Right. So for me, it really comes down to what am I seeing as to whether or not it's a contentious issue. A lot of people have rightly come down on the side of seller should complete provided that it has started prior to the closing date, which is different than I've treatment planned. And so seller completes. Why? Well, 1, they've already started the procedure. 2, they have the patient's trust. 3, never a good idea to commingle malpractice. So, okay, so that leaves us with who's responsible for the costs. Well, the seller is keeping the money because why would I do the work without the money? But the seller should be responsible for the costs associated with the procedure. Okay, so what are those costs? Well, do they have to charge for the office? I don't think so. Do we charge them for the equipment? Again, I don't see why. But actual costs associated with the completion of that procedure, they should probably be responsible for. So if there's an assistant being used, if there's a lab fee, if there's, look, I don't care about cotton swabs, but if there's like bone grafts and those types of supplies, probably should be getting reimbursed. And then you keep the residual. And if there's a unique circumstance where the seller can't complete it due to disability, death, or some other weird reason, okay, wonderful. We'll take it over, but we understand it's as a result of a specific issue, not because we think it's a buyer asset. And so that's probably why that can be contentious. Retreatment. I think retreatment is unique as well. Some regions, they want it 6 months. I don't get the 6 months. I also see 2 years sometimes. And I will admit, I sometimes try to get 2 years as well when there's no seller, no attorney on the other side. But I would say that for the vast majority of the country, 12 months from the closing date, the seller will stand behind their work. Now, where I see the divergence is, okay, how long do we go back? So is this 12 months for everything that's ever happened in this practice? Is it 12 months for a certain amount of years? Is it 12 months for 1 year? What is it? So I do see some more playing around of that as to the length of time prior to the closing date that the seller is going to be responsible for. I'm typically okay, if I'm on the seller side or the buyer side, with a 1 year prior to the closing date for any treatment performed within 1 year prior to the closing date, up to 1 year post closing date. I can't get that all the time, but that's what I'm usually comfortable with because I believe that's a proper balancing. Yes, if a crown prematurely fails and it's not as a result of, patient neglect or something like that, can you get it paid back for insurance? No, you can't because it prematurely failed prior to 5 years. And so, and I read somewhere that 7 years might be coming. I don't know. Anyways.
For statute of limitation?
No. For insurance paying on crowns. I read an article about that. But anyway, so now all of a sudden we can't go back to insurance. So who's responsible? That's where I think goodwill and a sense of common decency is, and that's the thing with contracts, right? We're law based. We're not emotion based. We're not morality based. We're factual and law based. But this particular issue is a balancing act, in my opinion, between goodwill and responsibility. In my opinion, if it falls outside of that time period where the seller's responsible, I have no problem telling my buyer clients, if I'm representing a buyer, look, this is a balancing act. This is a goodwill protection issue. You're not going to be able to charge the patient. You can't go back to the insurance company. This is just one of those, it sucks. You stand behind it, you do it. And you're going to find out that in the long run, as long as the seller wasn't like a complete, crackhead who is doing tons of bad work, you're going to be okay because you're actually building rapport with a patient because they understand that you didn't have to do this.
Yeah, I think that I agree with everything you're saying. I think that when it comes to retreatment, I think some attorneys may be counseling their clients wrong on the seller side, or they just don't understand the industry. Because the point of the retreatment section helps the seller more than the buyer. It prevents litigation and dental board complaints because there's a plan on how we're going to handle these problems so that the patients are taken care of. So most of the sellers I talk to tell me they really want the buyers because they really love their patients and they really want to find the right person to take care of their patients. But then if you tell them they need to put in a retreatment section, the perception can be, well, why are they trying to punish me? And an explanation is owed to them that this isn't a punitive provision. This is a positive provision for you because you are no longer working on these patients. So they're going to have some concerns about that. You left them with a different doctor or leaving them with the potential of having to go somewhere else. But they still may have problems that need to be addressed. And if we can bring a solution in place ahead of time, so if the patient comes in, we can say, oh, yeah, the seller had a plan for this in case there was a problem. That's going to make them feel better. So the buyer can articulate, we discussed this, we have a plan to help you.
Do you actually, I don't mean to cut you off, but do you actually have that exact conversation?
Yes.
That's awesome.
Yes, because I want my sellers to understand there's a value to the paragraph. And if we treat our patients well and we communicate well, we don't have litigation. We don't have dental board complaints. And so if we can work well with the buyer, then we're going to have continuation of goodwill, which is what you want. You want everything from a goodwill perspective.
Right.
And the seller doesn't get sued. So I think if we can get attorneys to understand so they can explain it to their sellers that this is not buyer's counsel trying to take money out of their pocket. Right? We don't want to try to turn it into a profit center, right?
Correct.
So we have limiting language in there, right? We pay the buyer if they do the work 50% plus lab. Some people get 60% plus lab. Maybe that cost should go up a little bit since the cost of supplies and staff, maybe everything should be a little bit higher. But they're not making any money on the deal, but they're maintaining the goodwill by treating the patients. And by doing that, they're keeping their practice intact, and then they're also keeping the seller from having litigation. I think it's a positive paragraph, and I agree. 12 months before, 12 months after is what I typically see. I don't like 3 years, 4 year, 5 year contracts, although you're right, there is an issue as to when insurance companies are going to pay for crowns. But I think what is important to understand is that paragraph is operative for the 12 months, and after that 12 months, the buyer is not required to notify the seller. And the buyer is not required to, get the seller's permission before doing the work. So after 12 months, it's, we need to have this relationship back and forth with the seller so that the buyer can come back to the seller and say, hey, how do you want to approach this? And I think the seller, for the same reason, should want to take care of the problem, although I don't want to make it mandatory 2, 3, and 4 years. So that's that issue on retreatment. I think that it's necessary. It's odd that the language has looked the same for 25 years, right? Hasn't changed all that much.
Maybe that's actually a testament.
Maybe. I mean, for implants, it changes a little bit because, the implant companies will pay for the implant and things like that. But going back to the unfinished dentistry, I agree 100%. When I started a root canal, I wanted to finish it. I wouldn't want anybody else to finish my root canal. I think if you're doing an all-in-4, all-in-6, those type of things, you're doing an immediate denture, those types of things, you got to finish that case. You don't want somebody else to step on it unless you can't do it because you're traveling, physical illness, disability, whatever. But but there are uncompleted dentistry things that we need to deal with that are more problematic, right? So orthodontics and implants, these are some uncompleted dentistry things that require a little bit more work.
Correct.
And maybe for another conversation, we can get into how do you manage the orthodontic unfinished cases and how do you manage those retreatment cases. But just trying to limit this a little bit in the podcast. What's this crazy paragraph, indemnification, and why is it 3 pages now in the document?
Indemnification, as you know, is basically I am going to stand in front of you as a shield, for lack of a better term, and protect you against things that I have either done or should have done. So, both in a negative sense, I failed in some regard. And I am standing as a shield in front of you. I will defend, I will represent, and so you will not take the blame. It is the quickest way of explaining. The buyer has an indemnification provision, and the buyer's responsible for anything post-closing, which the seller may be dragged into as a result of maybe the use of the seller's name, maybe just the fact that the seller sold the practice to them. Maybe there was a wrongful termination 9 months after the closing date, but the hygienist is suing the former owner, so those are all issues which the buyer would stand as a shield in front of the seller for. Now, the seller is going to stand as a shield in front of the buyer for anything that happened prior to the closing date. And so if they committed insurance fraud, if they misrepresented something, if they didn't pay an employee their overtime, all of these things, the seller remains responsible. The seller defends, meaning that they're paying for attorney fees, they're paying for any judgments, all those things. Now, what people need to understand is the indemnification is only as good as the person giving it. And so, if you've got a seller who is no longer in the country, that could be a problem. If you have a seller who is now bankrupt, that could be a problem. And so, it can be an issue. And so that's why we always say it's only as good as a person giving it. But I think it's long because this is a extremely litigious provision. And every single time it seems like it gets longer and longer because there was some loophole or some get out of jail free card or something on it. And so, I also think that a lot of people will take some of these big, I call them big firm, law firms, and they'll take that language and try to put it into these documents. And in some regards, it's overkill. But it can just be boiled down to you're going to stand and defend me for things you did. I'm going to stand in front of you for things I did.
Yeah, difficult section to read. Boring, makes you fall asleep, but probably one of the most important sections
Correct.
in the agreement. So, and we talked about this other issue a couple of times now, covenant not to compete, covenant not to solicit, covenant not to disclose confidential information, covenant not to hire staff, covenant not to treat. These restrictive covenants, they're there to protect the buyer. Should the seller feel insulted? Should the seller...
The number one most misunderstood provision in all of dentistry. I mean, I think there are more people who would be willing to tackle third molar endos or something like that than who get this thing right. I mean, it doesn't matter if I'm on Dental Town or other blogs or things like that. For every person that correctly gets a covenant not to compete and how it's interpreted, there's 10 that just completely do not understand it. And so there's just, and unfortunately, and I'm probably going to get flack for this, but unfortunately there are state and national societies that get it wrong too. I had to fight with the Texas Dental Association because they put out a blurb saying that covenants not to compete were no longer enforceable in connection with dental practice sales. Yeah. And they put it out. And so what did I do? Oh, it took me all of 10 minutes to find who the author of the bill was, call the senator from Texas, talk to the legislative affairs person, say, is this what you meant? For them to say, no, that's not what we meant. It was only in relation to covenants not to compete in connection with the employee-employer relationship.
Right.
Sent me the subcommittee language where someone tried to put in for business sales as well. It was rejected. And yet still, because the Texas Dental Association, in their infinite wisdom, screw you guys, they hire a big law firm. The big law firm says, no, that's not how it is. Spent thousands, tens of thousands of dollars putting that publication out, and they were wrong. It took me 10 minutes to get to the bottom of it, but no one spent the time researching it. And now you have thousands of dentists in the state of Texas who believe that covenants not to compete in a dental practice sale are non-enforceable. Imagine what's going to happen when people start to say, they sell their practice, they go 2 miles down, and they go, oh, well, the Texas Dental Association put this out saying that they weren't enforceable. That's going to be fun. So let's just say that my scathing email to the executive director probably meant that I'm never speaking in Texas again. Mm-hmm. So, but again, it's like, this is what dentists need to understand. There's a lot of people in this industry that just abdicate, what's the word? Abdicate? Yeah, abdicate their responsibility. And so let me be very clear. Covenants not to compete in the connection with the sale of a business are 100% enforceable in every single jurisdiction in the United States. Now, what is important is that matters as to what state you're in. So in almost every state, a covenant not to compete is enforceable as long as it's reasonable in scope and duration. Scope is geographic area, duration, time. And so there are some states like Florida that have provided very clear lines as to what is and is not enforceable in connection with an employee-employer relationship as well as a business sale. It is what's called presumed enforceable, as long as you fall within these time periods. But then you have a state like Louisiana, and you're like, okay, I see you, Napoleon, because you guys are crazy over there, and they still are in a different system of judicial enforcement. And so their covenants not to compete, you can't use miles. You have to use parishes. You have to use for anybody else outside of Louisiana, and I think there might be one other state that uses parishes, but parishes are basically counties. And so you have to use parishes, and then it can't be more than 2 years. So if I'm an attorney, I don't know that. You know, I'm a Colorado dental attorney, and I'm trying to do a deal in Louisiana, and I don't know that, and I put in a 5 year, 10 mile, which would be normal in most jurisdictions. Now all of a sudden my client's screwed. So it's extremely important to know what covenants are enforceable depending upon the jurisdiction you're in. But understand that they're reasonable in scope and duration, and reasonable is different no matter where you are. A 75-mile covenant not to compete could absolutely be enforceable in South Dakota. A 75-mile covenant not to compete will never be enforceable in LA County, in New York City, in Chicago. It never will be enforceable. And so you need to know what is and is not enforceable. You need to be using people that understand this as well. So unfortunately, it's an area that many people don't understand. Many people, I think, get into trouble over it because they conflict the employer-employee relationship with a buyer-seller relationship. So.
Yeah, and I think this brings us back full circle.
Right.
When we talk to sellers and we ask them, are they financially ready and are they mentally ready? If their perception is that the covenant not to compete is not enforceable without doing any studying, talking to an attorney, understanding where they're at, and they sell their practice, and think they can go 2 miles away and open the practice, and now realize that in fact the covenant is enforceable, and now they're having to drive 2 hours to go to work and 2 hours to come back. It's a significant issue. So we try to have that conversation up front with sellers and say, this is the area you're working at, and there's absolutely going to be a covenant if it's reasonable in scope and time. And that reasonable from state to state, as you mentioned, there's different tests on what reasonable means. But I think it's important that sellers have that understanding when they list their practices or when they sell their practices, that if they think they're going to keep working, they need to know how far they're going to have to go to work and whether or not, like I said, whether or not the covenant's enforceable or not. So I think we've kind of hammered the purchase and sale agreement. I'm sure there's other things we can talk about, but the big issues are reps and warranties and making sure that we understand as much about the seller's operation of the business before. They understand who the buyer is and the buyer understands the risk going forward. We understand that some post-closing issues are significant, hiring, firing staff. We didn't talk about that too much, but how we calculate accounts receivables, that was another podcast we did, covenants and their enforceability. We also talked about uncompleted dentistry and retreatment and how that impacts. And all of that makes up the 30 or 40 pages, which seem to get longer and longer, especially in this world of ChatGPT now, where people can run something through a ChatGPT, which will put in all these ridiculous things that they think they can get changed in a document that will not survive a negotiation. So. Right. So anyways, that's what it is to deal with purchase and sale agreements. It's a necessary evil to get your practice sold. It's a necessary evil to buy the practice. And it's something you need to have good legal counsel on. I will say this, if you hire a dental-specific attorney, you'll pay a fraction of what you'll pay if you hire a non-dental specific attorney. If you hire a non-dental specific attorney, you're going to be training them what the issues are, and you're going to spend $30,000, $40,000 on a transaction that you might get done for $10,000 or $15,000 or less with a dental attorney. So hire dental attorney, dental CPA, dental consultants, and people that know your business so you don't have to educate them. You should be educated by the people that you're hiring. So thank you.
If you have any other questions, feel free to click the link below, and hopefully we can assist you in that process.